This issue implicates a pretty significant role assigned to Congress by the Constitution, which is to determine under what circumstances action by a federal judge might warrant that judge's impeachment and removal. Judicial impeachment is and should remain, should always be, something that we would hope would be rare. The Founding Fathers granted life tenure for a reason, and that is to protect the independence of the federal judiciary. The point there is not to shield them in absolute terms from all accountability, but rather to protect their independence while also preserving a mechanism by which to address acts of significant wrongdoing. Article 3 itself guarantees that judges will hold their office for presumptive lifetime terms, but only during good behavior. When a judge disregards the rule of law, undermines the separation of powers, endangers public officials, or otherwise acts in a manner that takes him or her outside the universe of what we would call good behavior, as described in the Constitution, the Constitution requires, or at least contemplates, that Congress will take notice. In such circumstances, Congress may use impeachment and removal to restore constitutional balance and public trust. Our republic would be undermined, and some might argue that it couldn't endure properly if judges were permitted to display partisan bias, flout binding legal authority, or otherwise disregard and disrespect their judicial role. We've recently witnessed some troubling developments in these areas. One that I'll mention at first is the attempted assassination of a sitting Supreme Court justice. On June 7, 2022, Nicholas Roski traveled all the way from California to the Washington, D.C. metropolitan area carrying a gun, a knife, and some other equipment, all with the intent of murdering Associate Justice Brett Kavanaugh. From the airport, he went directly to Justice Kavanaugh's home and abandoned his plan to murder Justice Kavanaugh, only after observing the presence of law enforcement at the residence. Evidence showed that Roski acted with intent to influence the court, not just in the abstract, but in a particular case then pending before the Supreme Court of the United States, its decision in the Dobbs matter, motivated by anger over a draft opinion that had been unlawfully leaked to the press. Roski pled guilty to the attempted assassination of Justice Kavanaugh. The Department of Justice sought a sentence consistent with federal statute and consistent with the U.S. federal sentencing guidelines, 30 years to life. And the defense did not dispute that calculation. Nonetheless, Judge Deborah Boardman imposed a dramatically lower sentence of only 8 years. Now, at the sentencing, the judge emphasized personal circumstances, including family considerations and concern about prison placement based on Roski's asserted transgender identity. In so doing, the judge minimized the gravity of a crime intended to murder at least one Supreme Court justice to alter the course of one branch of government. Now, had Roski succeeded in what Roski had planned to do, the stability of our constitutional system would have been gravely undermined in ways that I believe were calculated to send us into a constitutional crisis downward spiral. A crime warranting decades of imprisonment should not, in those kinds of circumstances, warrant a mere 8-year sentence. Now, Judge Boardman reasoned that the prospect of 10 years in prison, which is not what she imposed, it was 8 years, but reasoned that a decade-long sentence would be sufficient to deter any rational person from attempting such an attack. That assertion reflects a serious misunderstanding of history and of the unique circumstances presented by this case, not to mention the apparent motivation of the defendant in that case. President Trump was nearly assassinated, not once, but twice, in 2024. just in the few months leading to the November 2024 presidential election. And then conservative activist Charlie Kirk was murdered just a few months ago. Some cabinet members and some White House officials have been forced to move themselves and their families onto military bases just to protect them from violent threats. Then just this week, several windows in the private residence of Vice President J.D. Vance in Ohio were smashed during an attempted break-in of that residence. Thankfully, the vice president and his family were not at their Ohio residence at the time this occurred. When a judge treats the attempted assassination of a Supreme Court justice as an ordinary criminal case, and I'm not conceding here that that would have been appropriate in an ordinary case, but it certainly wasn't appropriate here. When that happens, particularly in a case like this one, it does raise pretty grave questions about judgment, about duty, about deterrence. Such extreme leniency in those circumstances, accompanied by what can most generously be characterized as extreme naivete about the motivation and repercussions of these kinds of actions, risk encouraging others to use violence to influence the judiciary, especially at a time when politically motivated violence is rising. Meanwhile, as Senator Cruz mentioned just a moment ago, you had protests occurring at the residences of individual Supreme Court justices. Throughout the Biden administration, particularly in the wake of the Dobbs opinion in 2022, and a few weeks before that, the illegally leaked copy of it, that inexplicably went unenforced, notwithstanding a prohibition in an existing federal statute. Then, more recently, we've had other problems, and these should all be things that concern us. The second example I'll point to today concerns judicial interference with the constitutional functions of Congress and, to a degree, of the executive branch. Chief Judge James Boasberg of the U.S. District Court for the District of Columbia made some decisions that affected congressional oversight in a meaningful way by imposing secret gag orders on telecom providers, despite a long-standing federal requirement mandating notice to members of Congress under circumstances in which their data, their telephone data, has been requested, has been subpoenaed. Now, these gag orders required private parties to facilitate what many have fairly characterized as politically motivated actions taken by the Biden Department of Justice against certain members of Congress. More recently, Judge Boasberg issued an order intruding into a confidential executive branch meeting involving a cabinet secretary and a federal appellate judge and senior Justice Department leadership, again raising serious separation of powers concerns. These matters are not mere garden variety day-to-day disagreements over judicial philosophy or statutory interpretation. There are a lot of different opinions on this committee and on this subcommittee on those matters, on how best to interpret a federal statute, on how best to ascertain the meaning of a federal statute, the importance to attach, for example, to the original public understanding of statutory text at the time of its enactment. But that's not what we're talking about here. These things that we're talking about here involve something much more fundamental. They involve the misuse of judicial authority, what Alexander Hamilton described as the abuse or violation of some public trust. Such misconduct, Hamilton explained, constitutes an injury to society itself, to our constitutional order itself. Congress does not approach judicial impeachment or any kind of impeachment lightly, nor should it ever. Of thousands of federal judges, only 15 have been impeached and only 8 of those convicted. But abuse of official power has always been recognized as impeachable and, under appropriate circumstances where the Senate finds it, removable. When a judge disregards sentencing norms in the face of an attack on the Supreme Court or repeatedly interferes with the lawful functioning of Congress and the executive, these are not routine errors arising out of some good faith, genuine disagreement as to canons of statutory construction or otherwise. These are not things that can simply be corrected on appeal on a case-by-case basis. They're breaches of the public trust that have the ability to circumvent the constitutional order, and they demand congressional scrutiny.